Hi, my name is Carr Ferrell. I'm a patent attorney. I've gotten a little bit behind on some of my comments and emails, and I'd love to have your help with this today. Put your comments and thoughts in the comments section below, and we'll go through these together. Timco48 writes, "Hey John, I just submitted my provisional patent application. Now what comes next? Do you know if I'll receive any documents that they have on file?" Well, once you file your provisional patent application online using the Web Center, then about 3 weeks to 4 weeks later, you should receive a hard copy of your filing receipt in the mail sent to the physical address that you included when you filled out the Web Center web form. This filing receipt will indicate the day on which your patent application was filed. It will state the serial number of your patent application along with the title of your invention. And it should also include a foreign filing license, which gives you permission to file your patent application in foreign countries if you choose to do so. Again, you should expect to see that in your mailbox in about 3 to 4 weeks. Kid Newton writes, "If I use an AI image generator with a specific prompt, do I own the design trademark of that image if I file for it? Should I also file for a design patent?" When thinking about content generated by AI, we understand that only humans can be authors for purposes of copyright, and only humans can be inventors for purposes of owning patents. Trademarks are a little different. Trademarks are symbols or words that designate the source or origin of goods. When we register a trademark, we're not registering ownership of the word or symbol itself. We're registering the association, the use of that word or symbol with a specific product or service. So for this reason, if AI generates a symbol or makes up a word, you can use this word or symbol as a trademark, even though you may not be the author of the word or symbol. Once that word or symbol is properly used and registered, then you own the trademark for that word or symbol within the limits of the registration. And then there's the question of design patents. Design patents are a form of patents and fall under patent law. And we already know that only humans can be inventors on a patent. Since an AI cannot be an inventor under patent law, and you did not create the design yourself, but rather AI did, then in this case, there can be no registration and no inventor for purposes of getting design patent under patent law. Now, there's one small caveat when using an AI to create a design or to create a work of authorship. And that may be that there's some contractual relationship between you and the publisher or the author of the AI itself. So when you're using AI to create a work product for you, be aware of what contractual limitations you might have on the use of that work product in commercial business. Okay, Kid Newton has one follow-up question. He says, "I used prompts in AI to create an image, and then I took that image and created a real-life 3D model. Who owns the rights to that model?" Okay, again, subject to any contractual limitations with the author of the AI itself, you might in fact be the owner of this 3D model. The AI generated a two-dimensional image, and you took this two-dimensional image and you added information and creativity and artistic design. And in doing so, you created a 3D model. Now, depending on the amount of creativity that went into converting that two-dimensional image into a three-dimensional model, you may have a good claim of ownership and authorship in a copyright in that three-dimensional model. Life in the Fast Game writes, "I'm filing a provisional patent application. Would I be better off to make claims now or wait until I'm ready to file the full utility patent application to make claims?" Well, provisional patent applications are informal documents. There's no requirement to include patent claims in your provisional patent application. Now, as I've stated in others of my videos, there is some misinformation on the internet that in order to file a foreign application and to get priority to the provisional patent application, it's necessary to include patent claims in your provisional patent application. That's not true. However, that fake news aside, I do like to include one patent claim in the provisional patent applications that I file. Now, there are generally two reasons why I like to include a patent claim in provisional patent applications. And this patent claim is not a narrow claim and it's not a particularly broad claim. It's just sort of a middle-of-the-road patent claim listing all of the elements that I think are important in the invention. The most important reason I like to include a patent claim is to provide myself with a checklist of the elements that should be described somewhere in the provisional patent application. I want to make sure that in the provisional application itself, whether it's a figure or a photograph or in the written description, I want to have some reference and some detail, an explanation of each element that I think should be included as part of the invention. A patent claim makes a great checklist. And the second reason I like to include a patent claim in a provisional patent application is that almost a year will have passed between the time I file the provisional patent application and I go to convert it later. This claim included in the provisional patent application will help remind me, at least as of the time that the patent application was prepared and filed, what was important about this invention. Now, it may be that the invention has changed. There's been some improvements in the invention. There's elements that should be included in the utility application which were not either understood or known about at the time the provisional patent application was filed. But in any event, I find it helpful to include at least one patent claim in the provisional patent application to remind me as to what I was thinking about at the time that the original provisional patent application was filed. 430 Shem writes, will a provisional patent filing qualify you for patent pending status? And the answer to that question is yes. When you're filing your provisional patent application or a non-provisional utility application using the Patent Center website, when you submit the patent application to the patent office by pressing return, and after the patent office returns a serial number to you, you are patent pending. You can use the words patent pending on your products or on your literature on your website. You are patent pending at the moment that you submit your patent application to the patent office. Next question. Cheesy writes, does my patent have a future? I made it from scraps in a cave with Tony Stark. Awesome. I don't know about a future, but it sounds like it has a past. Thanks for watching my videos. Hammy Dreza writes, hi, Professor John. I'm a PhD student in structural engineering, and I'm planning to submit a paper to a reputable American journal in about a month. Since I don't have much time, I'm wondering if I can use the abstract, conclusion, and all figures from my article for a provisional patent application before the paper is officially published. And the answer to this question is yes. Filing an academic paper is often a good way to get your provisional patent application on file quickly. There's a couple reasons for this. As it turns out, the paper itself is the publication. Everything that's being disclosed about the invention is disclosed in the publication. So if you include the publication as your patent application, at least to the extent that information was disclosed about your invention, it will be included. The second reason that I think filing an academic paper can be valuable is that the detail included in most academic papers, especially peer-reviewed papers, is actually quite deep. And it's likely to be more than adequate disclosure and description of the details of your invention. And especially if it's been peer-reviewed, if there's detail missing, or if any part of the paper is unclear, then the reviewers are going to flag this for you and give you an opportunity to change it before the paper gets published. Next question. Sricham35 writes, hi, John. Can you tell me how I can access my already filed application, as it's saying that it does not exist, but I do have an application number? Okay, so probably what happened here was that you filed your provisional patent application on the Patent Center website listing yourself as a guest. That is, you didn't have login credentials, but rather filed your application as a guest. Now, unfortunately, since you were a guest, it won't be possible for you to log back in and get information about your patent application. However, you did receive a serial number when you filed, when you pressed return and sent in your payment. And in about 3 or 4 weeks, you'll receive a hard copy of a filing receipt in the mail. Historically, it has been possible for you to register as a user and then contact the help desk at the patent office in order to connect your user registration with the serial number. However, all that changed a few weeks ago when the patent office changed the rules, requiring now that all users of the patent office website be registered users and have login information. So from now on, if you file an application, whether it's a provisional patent application or utility application, you will be able to see your filing records because you'll be a registered and logged in user. Okay, that's it for questions and answers today. If you have patent questions or questions about intellectual property, put them in the comments section. I'd love to read them and I'll try to respond as soon as I can. And if you'd like help with your company's patent applications or your patent strategy, I'd love to hear from you. Reach out to me at the email address below. Thanks for watching my video. I'm looking forward to seeing you on the next one.